have a question for Katarzyna. Thank you so much for your presentation. It was very, very interesting. You said that the rule regarding the distribution of profit applies to public companies, so there is no division whether it is joint stock company which shares are not publicly traded or listed on a stock market. So it's just for the joint stock companies. And what would be the important reasons to not distribute the profit? Would that be only economic reasons, or, for example, the use of the profit for innovation and development, or what would be reason that can be considered as important? Thank you very much.
Thank you very much for a question. This opinion regarding to all joint stock companies, now only to public trade company, and the origin of this case law is in judgment from 2007, when the Supreme Court had two possibilities how use arguments for solution very unfair situation in one company, and then the Supreme Court prefer the philosophy in important reason for non-distribution profit before abuse of majority votes for non-distributed profit to minority, because the majority has the other ways to obtain profit for a company. And according to current case law, what should be the importance for non-distributing profit? It could be the reasons given in the article of association, like creation of special fund which cannot be distributed between shareholders, or legal regime for companies which operate in special business area, like, for example, mining or water supplying, where this company must give some part of profit for future renovation of the infrastructure. So, and the other reason could be a necessity for new investment of company in future. But everything is about that the board of director must ex ante explain why the part of profits cannot be distributed to shareholder, and what is the other difference is that the court can examine in the matter if the reason is right. It's not only wording. Oh, it's enough?
Yeah, thank you.
Thank you.
Yes, it's truly interesting also that how the company law is shaped by courts, because this is something which is not written. Yes, we are saying every time that we live in a codified system where the law is applicable, but there are or via interpretation or by filling gaps of the legislation which are inherent to any legal rule, the company law is moving and it has its own dynamic through the court cases as well. The similar issue has not the solution in Hungary. We have classical cases in which the court said that there is no right per se to dividend. This is a possibility, and it's totally up to the decision of the general meeting to decide on this issue. So we see now a very interesting line of evolution that you must fundament the refusal on some reasons. Of course, this is happening in practice, and in many cases there are no dividends, even if the legal conditions are met to divide to pay dividends. But this links also this issue with abuse of majority, and if we are tackling the problem from that side, that can open other interpretations and broader interpretations as well, and maybe that can serve as a future revision of a much more conservative jurisprudence and case law in other countries.
I have actually two questions, I'm sorry. I have one question for Professor Mrazova and one for Professor Dugar. First, Professor Mrazova was mentioning the online establishment of companies. But my concern is, how is it going to stop the letterbox companies that are introduced? And that is a huge problem in the European Union. I'm the labor lawyer, and I'm dealing with posted workers. And I know that the posted workers are really getting into a problem of letterbox companies. And if the company is established online, how is it going to prevent the fraudulent practices? Okay, and I'm just going to straight away for the question for Professor Dugar. You're mentioning the corporate sustainability directive, but on reporting. And my concern is the directive on corporate sustainability due diligence, which introduced also the human rights due diligence and also environmental due diligence. But how is it going to be implemented into the national legislations? Is it actually going to work? Because my concerns are the posted workers in subcontracting chains. And how is the human rights due diligence actually going to contribute to the to deleting the fraudulent practices of posted workers? Probably the questions are a little bit complicated, but if you don't have the answer, it's also okay.
Thank you so much for your very, very interesting question. I'm not really sure if I would be able to answer it correctly. Of course, with the letterbox company, it's a huge controversy also with online formation. However, as I understood it, even you use the online formation now is the same as you would use the standard formation. So there must be some safeguards that the company would really exist. And the only thing that the company is established or for example, provided this virtual seat in Slovakia, which is only a mailbox, it doesn't necessarily mean that it's a shell company or it's a letter company. It's not illegal. However, I believe that there must be other safeguards, maybe not in the company law, but maybe in other types of law to actually prevent the illegal operation of such companies. But I think that there should not be any restrictions in order to set up the companies, because the actual illegal activity is usually done after the company is formed. So I'm not sure if I answered, but that's my position.
Regarding the sustainability reporting, where already the previous non-financial directive that was mentioned already had an obligation to report not only on sustainability matters but also on other aspects, which was also, just to briefly, I've searched it, on also in respect of social and employees matters, respect for human rights, anti-corruption and bribery matters. But the directive that you mentioned, corporate sustainability due diligence directive, its aim, it's not so much reporting, under reporting, but also additional obligations regarding the acting of the companies and proving how suppliers through the supply chain act. So that sustainability directive that I mentioned is focused on reporting, but I think the questions and matters that you are concerned will be more likely and even more addressed by that due diligence directive when it will be implemented, since it also foresees how company and management has to act according to that directive, and also how to has to prove it and take appropriate measures if the company finds out that some breaches, human rights, and so on are happening to the supply chain.
Please.
I have a question for Pauline. You mentioned this new legal form, the simplified joint stock company. We have a similar one since 2017 in Slovakia, which introduced the legal regulation, introduced new legal form that provide for many advantages. For example, minimum capital of €1, different classes of shares, a shareholders agreement, legal provision on drag-along, tag-along, and so on. So this new legal form was built to be used by mainly the startups companies. But what's the experience in Slovakia is that due to the fact that the shares must be registered, so also the shareholders must have an account in the central depository, this form is quite expensive for the initial stage of the startup, I would say. So what's happening in Slovakia, that even for the IT startups, the main legal form that is used is the limited liability company. So my question is whether this is the same situation or in Poland, or it's a bit different, or what's your opinion about this?
As I said, we have some simple joint stock companies, but from my experience, it is also that still the most popular form. It's also cheap because the capital of a limited liability company is 5,000 PLN, so it's about €1,000. So it is also, and it is a traditional form, more exercised by many investors who are afraid of simple joint stock company, which is not yet known in our legal system. For example, it is also very easy to establish a limited liability company. Since 2012, we have the S24 system, which is more easier and easier. And we can establish by the system the limited liability company. So it's the company of a first choice also with the startups in Poland. But let's see, 2,000 is quite a nice number. You may take the contribution in kind or in cash. In kind means work, means know-how, means your very specific abilities. So it is developing, but 2 years, 3 years, 2 years, it's still the short time to fully assess the future development of this kind of company. But yes, so far, limited liability company is still the most, the company of first choice, as I said. Thank you.
I have one more question for Professor Emil. Thank you so much for your presentation. It was very, very interesting. I just want to make sure that I understood it correctly. When the rule is considered to be mandatory, is when it infringes the creditors' rights and employees' rights. So it's not expressly stated in the law that when it infringes minority shareholders' rights that it's mandatory? It is also there. Okay, maybe then I just read it different. Thank you. Because then why was the question with the preferential shares? Wouldn't that be considered as the infringement of minority shareholder rights?
Yes, the cases, we have the text that when the law says that this is mandatory, one case, and there are 4 cases where it must be considered mandatory if infringes the creditors' rights, the minority rights, the employees' rights, or it is a barrier in the front of the legality control of the activity of the company or of the functioning of the company. So those are the 4 general cases which can be used for interpretation. And the main problem is that this control is really hard to make in the moment of incorporation. Because we have articles of association, and the judge makes the registration in Hungary, reads it, but it is really hard to imagine all the possible cases which will appear in the future to check if a certain rule can be used to infringe the creditor's right or the minority shareholders' rights. It is not an easy task. So we can have that, okay, the company gets green light, and later it becomes that, okay, this is something, a text in the Articles of Association which can be used in the detriment of the minority shareholders, and the company was functioning maybe years in this way until the moment when somebody took the issue to the court.